Antonyuk versus James. Is this the end of the Second Amendment? Let's talk about that. Hello, my name is attorney Rachel Moss, and I am here with brand new attorneys for Freedom attorney, Joey Hamby. So if you don't know about Joey Hamby, it's time to get to know him. He is an all-star attorney here in Arizona. He's one of the very few Arizona certified criminal law specialists. He has years and years of experience doing high-profile felony cases, and he is a great new member of our team. Joey, I'm so excited that we get to film our first video together today.
Well, thank you very much, Rachel. I really appreciate the introduction. I really appreciate the chance to get to go through this case with you, the Antonyuk versus James case. Of course, it's a federal case. It's been up to the Supreme Court. It's recently come back down because the Supreme Court has denied cert on a preliminary injunction, and now it's headed back down to the district court in New York to deal with. So I like the way you started out where I know there are people on the internet that are saying this is the end of the Second Amendment. Okay, it isn't. What this really is about New York's concealed carry law, about the way they permit individuals with their ability to carry firearms and where they can carry firearms in the state of New York. It's another one of the many, many battles over the Second Amendment in these United States. So first of all, let's talk about what Antonyuk is and what it is not. Understand, for all of our folks out there listening, this is not a final decision on anything. Mm-hmm. In fact, it's been over 2.5 years since Antonyuk was filed, and we're just now getting to the part where they're going to litigate the case. This last 2.5 years has been spent going back and forth up to the Second Circuit twice, up to the Supreme Court twice, just on the issue of preliminary injunctions. So this is not a final ruling on the law in the state of New York whatsoever. It's simply a final ruling on the preliminary injunction status. Now, there may be more filings of that nature, who knows. The other thing to recognize is that this should not be a surprise to folks who practice in this area. Preliminary injunctions are, by their very nature, they're a type of interlocutory appeal. Mm-hmm. Superior courts do not like those coming up to them, and the Supreme Court doesn't generally like to deal with those. They would much rather deal with a case that's fully developed. In this case, hasn't been developed at all. Mm-hmm. So they would much prefer to have this case come to them in a fully developed manner with the case law, the arguments, the experts, all of that packaged up, and it simply has not been. So I don't believe this should be a surprise to most practitioners, and of course, like I said, this is not the end of the Second Amendment.
Exactly, but we understand to the general public, these kind of decisions can seem a little scary at first, because here we're looking at serious restrictions on New York citizens' Second Amendment rights. And even though this is a temporary decision, this is just a preliminary injunction being upheld in some ways and vacated in some ways. This is something that New York citizens are going to have to live with for a few years until the finalized case really makes its way through the system. So there's real effects on real people here, but this is kind of what New York does. This is not New York's first rodeo in making these types of restrictions for gun owners, but we understand here that these types of decisions can feel discouraging, but we're in a good position with our current Supreme Court. I think when this case really has developed, we might see some changes here.
Yeah, so I certainly agree with that. So first of all, yes, we should not downplay the real-world effect this has on the citizens of New York. The reality is New York had a statute, mm-hmm. and we're going to go through this in depth later on for those who care to listen to it in depth, but that statute was overturned. Then in response to that, they passed another statute that's the current statute that's actually, as best I can tell in a review, it's actually even more restrictive. Not less restrictive, it's more restrictive mm-hmm. than the regulations that they had in effect. And so, again, if you are a law-abiding citizen in the state of New York, you wish to get a permit to carry a firearm concealed, you wish to be able to carry it in various locations in the state where you would like to be able to protect yourself, this is a serious blow. There's no question about that. But it's not a serious blow that the court has caused to occur. This is mm-hmm. a serious blow that the legislature caused to occur 2.5 years ago, and now the court's simply saying it's going to stay in effect while the case is being litigated. So that's the reality of this situation. But we can certainly get into it a little bit more and talk about kind of the factual background and the procedural history of the case, which is pretty convoluted. and then talk about where this can take us and where the citizens of New York might well end up.
Exactly. Yeah, this takes me back to law school when we would have to brief cases and summarize them. Our law school professors would always expect us to do a little summary on procedural history, and usually it'd be a few lines. This is one where there's a really lengthy procedural history.
Yes. And so for our viewers, let's talk about two different things. You've got both the factual history, which tells you this is kind of the setting, the backdrop on which this occurred, and then you've got the procedural history. When we as attorneys talk about procedural history, we're talking about what's happened in court, not what's going on outside of court, but what are the facts of the case in the courtroom. And so those are two very different things. Let's talk about the background just a little bit. So we've got the factual background. As we know, and as most of our viewers will probably know, the real change in the law here in the United States really starts with Heller in 2008. Prior to Heller, our courts had almost uniformly found that individuals, citizens, did not have an individual right to bear arms under the Second Amendment. Then in 2008, the Supreme Court came down with Heller and gave an opinion that I think most of us believed in, but courts did not seem to believe in, which was that the Second Amendment protects not just a collective right to keep and bear arms, but an individual right for individual citizens. That was followed by a series of cases. There was McDonald versus Chicago in 2010, which seemed pretty clear to all of us that the Second Amendment applied to the states through the 14th Amendment. I thought that was decided case law, but apparently the Supreme Court needed to remind people of that. That was followed by Caetano versus Massachusetts, again affirming that the Second Amendment applied to all types of bearable arms, not just those that were in existence at the time of the Second Amendment when it was passed. Then came the really big shift.
The reason we're here today.
The reason we're here today. I'll let you talk about that a little bit.
So then you've heard us talk about this a lot on this channel, everyone's favorite Second Amendment case, Bruen. So Bruen really changed what the standard was for determining whether certain laws can be constitutional. So the Bruen test, first you have to determine, does someone's conduct fall under the Second Amendment? And if it does, then that conduct is presumptively protected. If not, then the government would have to provide evidence that the law that they are seeking to uphold is consistent with the government's historical regulation of firearms. So they have to find historical analogs, and I know we've gone into it a lot on this channel, pointing out what the state likes to point to when trying to show that there is a historical regulation of firearms in this country. So Bruen really changed everything in the ways that courts had to assess whether laws were constitutional or not. And it caused a lot of confusion among courts. And we saw a lot of courts were applying the Bruen standard differently. And what it really came down to was, what does it mean to have a consistent historical analog? And that's when we got another big case, Rahimi. And Rahimi helped clarify things a little bit. I think we still see a lot of confusion out there, especially, for example, we've been talking about the felon in possession cases recently. Yeah. And we've seen that even post-Rahimi, courts are really splitting on how to apply historical analogs in cases like this. But Rahimi narrowed the standard a little bit and informed courts that you, when looking for a historical analog, do not need to find a historical twin. There doesn't need to be the exact same law in 1800 that we have now in 2025 in order for it to be a constitutional enforceable law. But there does need to be relevantly similar laws that the state can point to in making these arguments. So with Bruen, Rahimi, a lot has changed, and this is why this case is being litigated now.
And that's right. I think for people to understand the real sea change that happened with Bruen, they need to understand the way courts were analyzing these types of things before Bruen. Mm-hmm. And before Bruen came down, kind of the standard way that courts would review firearms regulations is first they would look to see, is there historical evidence that shows that the type of conduct that the government is trying to regulate, is that historically included in the Second Amendment or is it not? And if it is not historically included inside the ambits of the Second Amendment, then there's not going to be any constitutional protection. If it is unclear as to whether or not it's included in the Second Amendment historically, then the courts would apply something they call an intermediate scrutiny. That's where they're going to determine if the regulation is substantially related to an important government interest. And that was kind of this two-step process that we went through. And I think it was Justice Thomas that said in the Bruin decision, well, 2 steps is 1 step too many. It's a great line that he had in that. But in essence, what they've really done, if they said, look, you've got to look for the historical context here. That's a good thing, and it's also a bad thing. Okay? The good thing is that, yes, you need to understand historically how this has worked. You've got to have context in laws. You just have to, otherwise you can unhinge them from any piece of reality and do all sorts of things with them. The problem is with context is that everybody can give their own context. And this is what we've done to some degree, is we've said, well, we're looking for historical context. We've now almost created this situation where we're going to use dueling historians. I'm going to go out and get my historical expert. You're going to go out and get your historical expert, and we're going to try to get a history that supports the outcome that we want. And I think we've all heard and read the saying about how history is written by the people who win the wars, right? Written by the victor. Well, basically then people try to rewrite history a lot. We see a lot of that going on. So there's some good and there's some bad that goes along with that. And I think that's caused some of the issues that we're having, like with Rahimi and some of the other cases. And so, the Supreme Court's trying to step in and give some guidance as to what we can look at and what we can't, and what the courts can look at and what they can't. So I think it's important to recognize, though, that what Bruin really did, is it really shifts the burden onto the legislator that's trying to propose the legislation as opposed to the person who's trying to defend themselves. And it basically said, if you want to uphold this law, you've got to show that there's a historical context that supports it, as opposed to the individual trying to say, no, my conduct fits within the ambit of the Second Amendment historically. So it really kind of shifted the burden onto the states, and the states that favor more gun legislation aren't happy with that. Mm-hmm. So that's kind of the context that we have that really shifted the world in Bruin. And then, to give people just a little background in terms of not just the legislative history now, but with the factual history there. So when Bruin came down in 2022, it effectively gutted a lot of the New York state law on how they permit folks who wish to carry in a concealed fashion and where people may carry guns in the state of New York. It really just gutted that. Mm-hmm. And that caused an immediate reaction, a political reaction from Governor Hochul as well as the legislature of New York. And they immediately came out making some statements about the things they were going to do. And they very, very quickly passed something called the Concealed Carry Improvement Act.
Not what I would have named it.
Yeah, very. I guess it depends on which side of that line you're on. But really what it did was it made it extraordinarily difficult to get a permit and to carry a firearm legally. There were some unbelievable aspects of this law, and those are the aspects that actually are still not being allowed to be put into place. And we'll talk about those in just a little bit. But there were just some very, very broad and far-reaching aspects of the law.
Before Bruin, an applicant for a concealed carry permit would need to demonstrate that there was proper cause. That was the terminology they used. And Bruin specifically addressed that proper cause requirement. So with the Concealed Carry Improvement Act, I think it's New York pointing and saying, hey, look, we took out the proper cause requirement, but we're left with a licensing requirement that's very difficult. They added something called the good moral character provision that really makes it a little more difficult to get a concealed carry permit and still imposes a lot of discretion for New York licensing officers to determine if people get to exercise their Second Amendment rights, essentially, in the state of New York. So the Concealed Carry Improvement Act is really the focus here in this case, and that's what the plaintiffs are challenging.
Yes. So let's just talk about the case for just a second then. So first of all, now we're going to move into the procedural history. So this is a very convoluted procedural history. Most folks think you file a case, you go to court, you have some litigation, maybe trial, and you're done. Not so when you're dealing with issues that are at this level. So first of all, the complaint in this case was filed on September 20th of 2022. Now, today we're on May 14, 2025, so almost 3 years later, over 2.5 years later, and we're just still at the end of the first phases of this case. That gives you a little bit of a sense of the time frame here. But the first thing that happened was there were a number of folks who filed complaints. Not just one. There were several complaints that were filed around the state. They were eventually consolidated into this case, originally under a different name. Now it's under Antonyuk versus James. So they filed a complaint, and among other things, various parties asked for different types of what's called injunctive relief. Injunctive relief is where you're trying to stop something from happening right up front, saying I'm going to suffer irreparable harm if this is allowed to go forward, and then you sort things out later on in the case, but you stop the harm from happening. And so what the folks who filed for injunctive relief were saying was, look, I will lose my constitutional rights during this entire time period, and I can never get those back, and so please stop this law from going into effect. There were actually a number of district court judges that actually granted injunctions, and in essence, they pretty much put a stop to the entire law. The state of New York, of course, then said we're going to appeal that. So this is the first interlocutory appeal. It went up to the Second Circuit. The Second Circuit essentially said, well, we're going to overturn those injunctions. There were some minor things that they left in place. They're going to overturn those injunctions. That was appealed to the Supreme Court by the plaintiffs in this case. The Supreme Court looked at it, and meanwhile, while all that's going on, the other case we've talked about, Rahimi, was also in the works and was decided. So between the time that the case was appealed to the Supreme Court and the time that the Supreme Court ruled on it, they ruled on Rahimi. Then they sent this case back to the Second Circuit and said, look at it again in light of the direction we've given you in Rahimi. As best I can tell, the Second Circuit gave that a wink and a nod and said, well, we're going to essentially do exactly the same thing. We've looked at your guidance in Rahimi. We already followed it in advance. And so they gave almost exactly the same opinion in the ruling, basically turning down the injunction or overturning the injunction. That was appealed again to the Supreme Court. And why we're here is because the Supreme Court just recently said, we're not going to listen to the injunction anymore. Go down and litigate the case in the lower court. And so that's where we're at right now. And in fact, as we sit here right now on May 14, the case is currently scheduled for a scheduling hearing on June 9. I don't expect that to take place. Somebody's already filed a motion saying I can't be there. I need to extend or continue that hearing, and so I don't expect that to happen maybe even in the month of June. It might be July before they have their first scheduling hearing on this, and then we'll have a little better idea of the time frame. But at the same time this case is going on at the lower court level, there's all sorts of cases that are already in the pipeline, either in circuit courts or in the Supreme Court, that may come down and may actually make additional changes in how these courts are supposed to handle things. So in a nutshell, that's the procedural history of this case. There's a lot more in the details, but that's the procedural history, and that's why it's taken basically over 2.5 years to get to this point. 2 trips up to the Supreme Court.
And there's probably a couple years to come on this as well. And this is not too unusual for these types of cases dealing with constitutional issues. But that's why at the top of the video, Joey said, is this the end of the Second Amendment? No. We're still actually, even though it's been 2.5 years, we're still at a relatively early stage of the case, which is crazy to say. With that, I think we can dive into the case and actually discuss what are they looking at here? What are they looking at in terms of the Concealed Carry Improvement Act? The plaintiffs here were challenging a few different provisions of the Concealed Carry Improvement Act, and it falls into, I would say, 3 basic categories here. So the first category would be challenging the licensing provisions themselves, and that falls into a few things. So the first licensing provision that they challenged is the discretionary aspect of the law. The plaintiffs were arguing that the licensing officers essentially have too much discretion here under that good moral character provision. And that is not consistent with our nation's tradition of regulating the Second Amendment. There were a couple other things they challenged, including the social media provision as well. So under the Concealed Carry Improvement Act, if you were applying for a concealed carry permit, you would have to provide all of your social media accounts to the licensing officer. So they, even ones that are under a different name, ones that are private, ones that are public, all of your social media accounts, you have to say, hey, government, take a look through my social media. Go right ahead. They also asked for information about all cohabitants. So in your house, if you have wife, children, roommates, friends that live with you, you have to let the state know that as well, and you have to get references from those individuals. So really applying for a concealed carry permit in New York is a very burdensome process, involves a lot of government intrusion, and the plaintiffs were fed up with it. They wanted to challenge this, say that it's not consistent with our nation's historical regulation of firearms. And that's the first kind of category here that the court was considering when reviewing the injunctions.
So you're right on all those points, and I think there's some very important things to flesh out here. So first of all, let's deal with the social media aspect. Okay, there are two very troubling aspects of this. First, let's just be very clear. That's actually one of the provisions that even the Second Circuit has said that's a bridge too far. Mm-hmm. So that provision of New York's law is still enjoined. In other words, it can't be enforced on a preliminary basis while the case is going up. And I don't expect anybody believes that that will be upheld, quite frankly. The real issue here is not that the government can look at your social media, because the government has investigators. That's what they do. They can look into people's social media. That's not illegal. That's not a crime. You're putting this stuff out on the internet. Folks can look it up. Look, if you are advocating for the violent overthrow of the United States online and the government finds that, I think that's a relevant point to look at as to whether or not the government should have you armed walking around in all sorts of areas. I think that's a concern. On the other hand, that's not what this law mandates. What this law mandates is not that the government be able to investigate you, but that you have to walk in and hand them all this information. Now, imagine this in another setting, which is you have a position that is unpopular with whatever your local government is. Okay, you support one candidate over the other candidate, and now they see that. There's two issues here. One is that you're required to divulge information about yourself that you might not want people to know for a political reason, or maybe a religious reason, or maybe a personal reason. But yet if you don't disclose that, that could be a reason to deny you your right to carry in a concealed fashion. The other aspect of it, though, is that what it's really doing here is, in addition to forcing you to divulge that and forcing you to lose your right if you don't divulge it, it's also now coming back into that other more arbitrary and capricious manner, which is the moral character. Well, who has the right moral character? If you have a different political belief or a different religious belief or just an unpopular belief of some sort, does that mean you don't have the moral character? And so requiring you to disclose essentially kind of your personal thoughts and feelings, even though you're posting them online, which is a different issue, that's very, very problematic. And that was very problematic for the Second Circuit. So that's actually one of the areas where they said that law is not viable. It's not going to be upheld at this point in time. So the social media one was a big one. But on the other hand, for some reason, they upheld, at least on a preliminary injunction basis, they upheld the state's ability to enforce the right to require you to disclose all of the inhabitants of your house, which seems really strange. Because again, here, the government can go out and send out investigators to knock on your door or knock on your neighbor's door and talk to folks and find out who's there and who you associate with. I'm not sure why this aspect was not more problematic to the Second Circuit, because it really impinges on your freedom of association. I mean, who you're married to or not married to, or who your kids are, who's living with you, those seem like very private things that really are problematic from a First Amendment setting, maybe even a Ninth Amendment setting that seems very problematic. So I'm not sure why that wasn't more of a problem for the Second Circuit, but clearly it wasn't.
They almost contradicted themselves in this way, because when discussing the cohabitant provision, they specifically stated, well, the government has all this information anyway, and it's in records. So this is really just a matter of making the licensing officer's job more convenient. And that's consistent with our nation's traditions. But then we look at the social media provision, and just like you said, this is information the government can access anyway. They can find this information online. They can do this investigation, but they treat the two things very differently.
They do, and I don't see a legal basis for that or a constitutional basis for that, so I just don't understand that aspect of it. So that doesn't make sense to me, and I'm sure it doesn't make sense to a lot of other folks. I think those were the two primary provisions. I know there were a lot of other provisions that we want to talk about in terms of where a person can carry and what they can do. So I think those were some of the primary provisions that were concerning. And again, the moral character, just to kind of flesh that out a little bit more, it really feels like all they did was take good cause and change it to moral character.
It's a rebrand.
Yeah, it's
They rebranded
rebranding.
it.
And really it still gives the licensing officer essentially unfettered discretion to do what they think is right.
Yeah, and this is how they defined the good moral character for license. It's the essential character, temperament, and judgment necessary to be entrusted with a weapon and to use it only in a manner that does not endanger oneself or others. And I think my idea of what that is might be very different than what a licensing officer's in New York idea of what that would be. And they really they're saying this is a substitute for determining dangerousness. And this is where we really get into where the historical analogs become important, because the state has put forth all of these historical analogs in their words that show that we have a tradition of regulating dangerousness in this country. And that's true to an extent, but I think there's a big leap here to say that that is what the good moral character provision is targeting, because there is, I think, clear room for abuse of that provision outside of determining dangerousness.
There's just a lot in that. First of all, it just strikes me that many people who would view themselves as civil libertarians often have the saying, well, we can't legislate morality. Here we're absolutely legislating morality, and we're absolutely saying you have to have a type of morality before we're going to allow you to have a certain fundamental right that's guaranteed to you in the Constitution. Secondly, in terms of this good moral character aspect of it, and basically trying to link that to the potential for endangering other people, I can only think of a way that is handled in a different setting. So many people may know or may not know, but when you decide you want to be some sort of a law enforcement officer, one of the things you go through is a battery of tests. And in many states, you have to go through things like the MMPI, the Minnesota Multiphasic Personality Inventory, which is a psychological evaluation to look at who you are and try to determine, are there aspects of your personality or your character that we may not want in a person who's walking around with a badge and a gun. And there are other tests that they do to try to determine whether or not this person will use the authority and the ability to use force that they're given in a wise manner, in a way that doesn't endanger others needlessly. Are we talking about doing something like that eventually? Some sort of psychological evaluation and testing for future dangerousness? That seems like they're really, really, really going out of the way to try to, again, just create barriers that people can't get over. It's really what that seems like. Exactly.
And I think we could touch base on the second category here as well that they're looking at. So you kind of previewed it for everyone, but the other thing plaintiffs are challenging here are what New York likes to call the sensitive spaces. So there's certain sensitive spaces that they're saying you are not able to carry a firearm. And these include kind of the usual suspects like nurseries, preschools, parks, zoos, places of worship, polling places, places owned by the government. So when you start looking into it, that covers most places. And so really the sensitive spaces provision is really important because it takes away a New York citizen's ability to effectively use their Second Amendment rights. So the plaintiffs wanted an injunction to say, okay, let's put a stop to this while this case is going on. They know this case could be going on for a while. So they want to be able to exercise the right to carry in these places while this case is pending. However, the sensitive locations challenge did not go so well here for the plaintiffs.
So it is a mixed bag. And I think to understand it, you really have to understand how broadly the legislature defines sensitive places. So again, you can say those words, and you and I might have an agreement. We might disagree a little bit, but we might agree, here's a sensitive area, here's another sensitive area, and this one's not so much. But the way they did it was they defined sensitive spaces to mean essentially almost the entire state. And I'm going to give you some examples. So one of the things they talked about was private property. Now, generally speaking, we know that if you are on your private property, that's one of the areas where you can certainly carry a firearm. Or if you're on somebody else's private property, that might default to what their requirements are one way or the other, because you can't tell people, this is the way that I can behave on your property as a general rule. So what they did there is they said, well, there's really two types of private property. There's private property that are open spaces for the public, and there's private property that are not traditionally open spaces for the public. As example, my house or your house, that's private property, and that's not generally open to the public. If I invite you in, you're an invitee, but you're not there as a member of the public. On the other hand, the nice folks at Walmart have private property, and they're holding that open for the public to come in and shop and engage in commerce with them, or folks at a restaurant or folks at a hardware store. Those types of places are private property, but they're open to the public. So we have those two distinctions. Interestingly, what they did was they said, well, essentially on private property, if it's private property that's not open to the public, you can't carry a firearm on it at all, in essence. And then if it's your private property, you can carry the firearm, and then if the owners give you permission, you can carry a firearm on it. There's some back and forth on that, because essentially what they're doing is they're preemptively saying what a private property owner is going to take a position on. And no private property owner is taking that position, and yet they're saying this is the law. Even if the owner would have said, no, I'm fine with you carrying a firearm, you could still be charged because the private property owner didn't specifically post it and say you can carry a firearm here. So that was one aspect that was very troubling. The other aspect of it, though, was that they said on private property that's open to the public, a hardware store, a grocery store, those types of places, that's a sensitive area, and unless it is posted in a conspicuous manner that you can carry a firearm there, it's illegal to carry a firearm there. In other words, what they were saying is, use an example. You've got a Lowe's hardware store, and the folks at Lowe's say, I don't care if you carry a gun or not. What they're really doing is they're putting an obligation on that property owner to post signs saying it's okay to carry firearms here, as opposed to the opposite, saying you have to post signs that say you can't carry here. So again, they're shifting the burden over and over. Now they're putting a burden on private property owners to say it's okay to do something here. So of those two provisions, interestingly, the circuit court has said, well, the private property that's not open for public use, it's okay. The law is okay on that regard. On private property that is open to public use, we're going to say that provision is problematic, and so we're going to uphold the injunction so that part of the law can't be enforced. There's one other area that has changed, but it wasn't because of the court, interestingly enough. And that was the area about carrying a firearm on certain types of religious spaces, like a church or a place like that. So originally what happened was one of the lawsuits that was brought by, if I recall correctly, a pastor who said, look, I provide counseling services. I provide those counseling services to folks who are in the throes of addiction, dealing with other issues, and I need to have the ability to defend myself on the space where I'm providing these services in my church, and you're preventing me from protecting myself in those settings. So my recollection is there was initially an injunction on that to allow that pastor to do that. Subsequently, even the state of New York said, yes, that's a bridge too far. They amended the law so that it now says that if you're providing those services, you can, in fact, defend yourself by carrying a firearm on those spaces. And the Second Circuit said, well, that part of the preliminary injunction is moot, meaning that the state has now essentially changed the law, so that's no longer relevant. So those are the kind of the high points, if you will, on the issues of where you can carry in the state. But effectively, right now, there are still vast swaths of the state where either you cannot carry or whether it is very unclear whether you can carry a firearm there legally or not, meaning you're walking around at your own risk in those circumstances. Just to wrap up where we're at with Antonyuk, the reality here is that we're really still in the very early phases of this case. The other reality is that whatever happens in this case will very likely be overshadowed by things that are happening in other cases. The reason for that is that there are other cases that are currently waiting to see whether or not they'll be heard before the Supreme Court that quite frankly are probably in a better position. They've been fully litigated. They've had testimony. They've had experts. They've had actual rulings as opposed to just preliminary injunctions. So I think it is very likely that we're going to see changes in the landscape prior to a ruling from the Supreme Court on Antonyuk. So I think we've got a long ways to go on Antonyuk, and who knows what things are going to look like when we get there.
Yeah, it's really exciting to see what's going to happen next in a case like this. But as we said, this is not a final decision for the Antonyuk case. The court did a lot of analysis here about the historical analogs relating to each of these categories, from treatment centers, places of worship, the licensing provisions, the catch-all provision, the social media provision, the cohabitant provision, the restricted spaces provisions. So they did a lot of work already analyzing the historical analogs. So we have a little bit of a preview that when this case works its way back up, we have a little bit of a preview of what the Second Circuit might do in the future on this. But just as Joey said, there's other cases that are a bit more developed that could be making its way to the Supreme Court before this case finishes its litigation. So we might see some changes in the landscape. I keep saying that I think we could see another Rahimi style case in the future that provides a little more clarity on the historical analog standards, because even after Rahimi, as we've discussed, we still see courts are a little confused about how to apply these historical analogs, and we're seeing what we like to call circuit splits, where some circuits are aligned on how to apply these historical analogs and other circuits disagree. And so at some point when you have the circuits disagreeing, well, someone's got to make the overall decision, and that's going to be the Supreme Court in the future. So what we're saying here is we're going to see more litigation one way or the other about these Bruin, Rahimi issues, and of course, we're going to keep you updated every step of the way. So again, I'm so excited that I get to be in Joey's first video here with AFF. If you enjoyed this video today, I encourage you to check our websites out. You can check out Attorneys for Freedom at attorneysforfreedom.com. We are the only law firm in the United States that handles only self-defense cases. So if you want to learn a little bit more about us and our team, check us out on our website. You can also check us out at attorneysonretainer.us. Attorneys on Retainer is a self-defense protection program where if you are a member and you find yourself in a self-defense incident and you are charged with a crime or reasonably expect to be charged with a crime, your legal fees will be covered. So you got to check out the Attorneys on Retainer program again at attorneysonretainer.us. If you enjoyed this video, you know what to do by this point. Go ahead and like, comment, share, and subscribe.
Thank you all very much. I hope we were able to share a little bit of information with you that you weren't aware of yet. If you have any other issues or questions, always feel free to reach out to us.
Until next time, peace.
Peace.